start shortly. The proceeding will 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 start shortly.
Order, order. Thank you very much for coming to talk to us today about tackling online abuse. This is our committee's 4th session on this issue. So far, we've heard from stakeholders, including petitioners, who have been directly affected by online abuse. We've heard from organisations representing people who are disproportionately likely to be victims of this behaviour online. We've heard from experts in technological and regulatory solutions to online harms, the Law Commission and social media companies. And so we're really looking forward to questioning you today, Minister, about the government's efforts to tackle online abuse, including through the Online Safety Bill. But before we launch into our questions, could I just ask you both to introduce yourselves, please?
Yes, certainly. My name is Chris Philp. I'm Member of Parliament for Croydon South, and for the last 3 months I've been Minister for Technology and the Digital Economy. Before that I was a Minister in the Home Office and Ministry of Justice.
Thank you.
Thank you. Good afternoon. My name is Orla MacRae. I'm the Deputy Director for Online Harms Regulation in the Department for Digital, Culture, Media and Sport.
Thank you. Thank you very much indeed. So we've spoken to a number of young people in schools across the country, and the message has been very clear that they feel that facing abuse is just a normal part of the online experience. So what do you think are the most important things that the Online Safety Bill will bring about, will change or will do that they're not already doing in terms of the online platforms? What will the Online Harms Bill, Online Safety Bill, achieve in order to tackle the abuse that's on these sites?
Well, thank you very much indeed for the question, and thank you for the opportunity of appearing today. It's probably worth saying a word about where we are in the process with the Online Safety Bill, and then talking about some of the provisions which may assist in dealing with some of the terrible problems that you've just touched on in your introductory remarks. In terms of process, we published a draft bill earlier this year. That's been going through a process of pre-legislative scrutiny, including by a committee of the Commons and the Lords sitting together, chaired by Damien Collins, which I believe intends to report around about Friday of next week, Friday the 10th of December, give or take a few days perhaps. Once that report has been received, we will then make changes potentially to the draft bill to improve it, strengthen it in some areas prior to introduction a little later on this session. So in process terms, that's where we are. The government is very, very open to listening to various stakeholders and to parliamentarians, of course, as well, including this committee. And we are very open to the prospect of making changes to strengthen the bill even further compared to where it is today, because the Prime Minister, the Secretary of State, myself, other ministers feel, as I think most parliamentarians do, very strongly that there are problems with the online world affecting children and adults, and a lot more needs to be done. So we are keen to make sure this bill is as effective as it possibly can be prior to introduction, and I'm sure then very extensive debate in Parliament. In terms of the measures as they're currently drafted, the bill is structured around kind of 3 pillars. And it's probably helpful just to go through each of those. So the first pillar covers content that is illegal. And where content is illegal, then there is a duty on in-scope social media companies to prevent that illegal content. And for the priority illegal content, which will include things like child sexual exploitation, terrorism, and other things that will be specified, then there is a duty not just to take it down when they spot it, but to proactively seek to identify it and prevent it. And I think that is an area which I'm sure everyone will agree is a good idea. Illegal content just shouldn't be there at all. The second area where there will be duties on social media firms is in the area of content that is legal but is harmful to children, and that, I think you may have touched on that in your question. And where there is content which is likely to be accessed by children and which is harmful to children, there will also be a duty on social media platforms to prevent that, regardless of what their terms and conditions may say. That'll just be an absolute obligation which sits on them. There's then a third area, which is the more challenging one in sort of policy and principle terms, and that is content which is legal. So Parliament hasn't passed any law saying it's illegal, but which is potentially harmful to adults. So that might be things like, content which is, for example, racist, but not to the point it crosses the threshold of inciting racial hatred, for example, or that breaches the current law. So offensive, but not unlawful under laws as they currently stand. So in those areas, there's a sort of balancing act to strike. We obviously want to respect free speech, but at the same time, make sure that hateful content is properly dealt with. So the way the bill addresses that is by requiring the largest companies, the so-called Category 1 companies, so those are the sort of Facebook sort of size companies, TikTok, Snapchat, Instagram, those sort of companies, requires them to first of all do a full risk assessment, so they understand what risks are posed. Secondly, to be really clear about what they're doing to deal with or to address that harmful content through their terms and conditions. And then thirdly, so it's forcing transparency effectively, and then thirdly, requiring them to stick to their terms and conditions, because very often the terms and conditions will prohibit like racist, for example, or misogynist content, but those terms and conditions are not properly or consistently enforced, so there'll be a duty to actually enforce their own terms and conditions. All of those obligations and duties that I've described will be policed by Ofcom acting as regulator, and if a company breaches those duties, they're liable for a fine of up to 10% of global revenue. So I've tried to summarise very briefly what's quite a big bit of legislation, but those are the key measures. It is a groundbreaking piece of legislation. I don't think any country around the world has attempted to do this so systemically and so comprehensively. It represents an enormous step forward from where we are today, indeed from where any other country is today. But as I said at the beginning, if there are ways we can improve this, we are really, really open to doing that. And I'm not sure if your committee is going to write a report, but if it does, we'll certainly be reading that with great interest and seeing if we can learn from its recommendations.
Yeah, we will be producing a report at the end of this inquiry, and obviously we're looking very much to reflect the concerns that petitioners have raised. So, hundreds of thousands of members of the public who have signed petitions because they'd like to see change on this front, and obviously the young people that we've spoken to as well as part of this inquiry. So do you
have a view on timing? Because we're looking to introduce the bill as quickly as we practically can, but after the joint committee reports. Obviously there's a bit of lead time in terms of developing policy, drafting and so on. Do you have a sort of rough time frame in mind? I don't want to put you under any pressure, but the earlier that we get your comments, there's more chance we've got of incorporating them.
Because if we're talking about timing, we'll be timing at what point are you going to be producing the draft legislation? Because obviously we've got pre-legislative scrutiny that you mentioned. Yeah. Could you be clearer on your timing?
Well, so the draft bill is published already in draft form, and the pre-leg scrutiny committee, the joint committee being chaired by Damien Collins, is going to report approximately on Friday of next week. We then the next sort of step would then be us publishing an updated bill or introducing it. We'll actually introduce the bill later this session. Obviously, we can sort of guess roughly when the session might end. So this session. But we won't publish anything else sort of before that. So we want to, as we update the bill, ready for introduction, we'll obviously look at the Joint Committee's report, but also look at everything that other parliamentarians say, including your committee, and I've done loads of meetings, as you can imagine, with all kinds of colleagues, Margaret Hodge, many, many others. So we'll incorporate their comments as well as part of the process of publishing the updated bill, or introducing the updated bill.
Great. Well, we can obviously keep in touch on the timing, but we were thinking sort of mid of January. We're hoping we'll be in time to be considered as part of your revised drafting. Okay.
So that will likely be before we publish the or introduce the updated bill. But if obviously I don't want to sort of trespass on your independence, but I would just say that the earlier you can publish your report, the more chance we've got of incorporating its recommendations, because there is quite a surprisingly long process of policy development, policy instructions, legal instructions, OPC, Office of Parliamentary Counsel drafting. It's quite a surprisingly long process. So just the earlier you can do it, the more we can incorporate your comments.
Okay, thank you. That's helpful, Minister. Because obviously I know there's a balancing act here between maximising the drafting process and getting it right, but also speeding up the process of getting this legislation in place, which is really what our petitioners want to see, and obviously we all do too. Just to sort of pick you up on a couple of the points that you highlighted there in your sort of opening comments there. Are there any specific features about how social media or other online platforms are designed, or their functionalities that they offer to users, that you're particularly concerned that may be enabling or indeed amplifying abusive content that you're seeking to address as part of the legislation?
Well, there's a whole number of things that concern us, which I think is why this legislation is so necessary. I mean, one thing is that they, as I said before, they don't enforce consistently their own terms and conditions. So if as a first step, they would just get them to properly enforce their own terms and conditions, that would be a big step forward. That's definitely an area of concern. You asked about the sort of inherent nature of social media platforms, and there is a concern because they can propagate content at a scale that other forms of communication can't. And so what starts off as a single tweet or a single Facebook post or Instagram post can rapidly get disseminated across like millions or even tens of millions of people in a very, very short space of time in a way that no other media does. Certainly not in a way that's as uncontrolled as this is. And I think so that's an inherent feature of social media that means that these things get amplified. But there is a particular concern that we're very conscious of, which I think Frances Hagan referred to, the Facebook whistleblower, in her evidence to the Senate, the US Senate, as well as parliamentary committees here, and in the documents that the Facebook internal documents that she quite rightly leaked to the Wall Street Journal, which illustrated the way that algorithms can pick up hateful content and amplify it and propagate it. Not because they have chosen to be deliberately hateful, but because they've noticed the algorithm notices that hateful content gets lots of, they call it user engagement, which then drive profit. So by running these algorithms which are optimized for user engagement and therefore for profit, they end up propagating, amplifying, disseminating, whatever word you want to use, upranking, often quite unpleasant content, and that is a concern too.
I mean, I guess the question is, what will the legislation do about that? So, you highlight that online media platforms aren't actually enforcing their own terms and conditions. I was also going to ask you about the categories that you highlighted in terms of the legal but harmful content in relation to adults in particular, because there are some sort of alternative platforms, for example, Telegram, BitChute, who would fall outside of the scope of it being a Category 1 platform. However, they are specifically designed, is my understanding, to actually promote hateful content, which would, I think, fall within the harmful category, but not within the Category 1 requirements. And just has the government considered including, as well as the size of a platform, the risk rating of a platform in order to categorise it in terms of the approach?
So a couple of points there. So first of all, in relation to the not abiding by their own terms and conditions, in relation to legal but harmful content for Category 1 companies, that will become a requirement now, so they can't duck out of that. On the algorithms sort of letting rip and propagating material, I mean, if the content is illegal or if the content is harmful to children, then that will be just generally prohibited. In relation to content that is legal but harmful to adults, for Category 1 companies, the big companies, and I'll come on to the definition point in a second, then they've got to do the risk assessment, and if they identify, and if they're going to let their algorithms promote harmful content, which at the moment they say they don't, but in fact they do, they'll have to be completely explicit about that, and it'll be visible to the whole world. On the question about the definition of Category 1, so those first two areas, the illegal stuff and the stuff that's harmful to children, that applies the first one applies to all firms, the illegal bit. The legal but harmful to children applies to any firm, any in-scope firm where there is a danger that children will see the material. So there's no kind of Category 1 or not Category 1 distinction in those two areas. The Category 1 distinction bites in relation to the legal but harmful to adults. And you're, in the definition of Category 1 is both high reach, meaning it reaches lots of people, like Facebook, and high harm, or high potential to commit harm. So there's an and in there. So one of the suggestions that has been made, which I'm not making any commitment, but we're thinking about, is you could change that and to an or, right? So it's high reach or high harm, as opposed to high reach and high harm.
That's helpful, thank you. Just one final question from me, and I'll hand over to colleagues. Our inquiries also heard about specific frustrations some users have in engaging with platforms. So, you might report harm, it doesn't get dealt with, or you're not fed back how it's been dealt with if it has. And so it's that sort of enforcing the terms and conditions. How are you going to, through the regulations, presumably that's a priority to address that, how do you believe the regulations will address that?
Well, the intention is the regulator, Ofcom, will make sure that platforms have proper mechanisms for user redress, so making complaints and then acting upon those complaints if they're meritorious. And if it turns out that the platforms are either just don't have a mechanism to deal with it, or they don't deal with it properly, or there are legitimate complaints that get ignored, ultimately if there is a systemic issue, so Ofcom won't be adjudicating individual complaints. So if person X has a complaint, Ofcom won't adjudicate that individual complaint. But if there is a systemic problem where a particular platform on a systemic and routine basis doesn't deal with complaints properly, then Ofcom will take regulatory enforcement action, or regulatory action followed by enforcement action in relation to that kind of systemic failure. Did you want to add to that?
No. Okay. I guess one of the challenges is the transparency around that, because there are many young people reported to us that they don't actually know how to report abuse. It's not made that obvious on some platforms. Others are doing a better job of actively encouraging that engagement so that they can address these issues. Are you confident that the legislation is drafted in a way that actually will encourage users to actually report abuse, which will become a community enforcement of terms and conditions?
Yes, I think we are. So I think there's two things that are relevant there. So one is the provisions in the bill about user redress specifically say that the mechanisms have to be accessible to users, including children, but also the parents and carers of children. The second thing that might be worth highlighting is our broader work on media literacy. So that's helping ensure that everyone is aware of how to report issues, how to use the tools available to them, which doesn't need to wait for the bill necessarily, but there's a great deal of work underway already on that.
Okay, thank you. Christina.
Thank you, Chair. If I may ask, what is the latest data the government has on the scale and nature of online abuse? And how has this affected the approach taken in the bill to tackle this issue?
Yes, so we've been working on this in the government for several years now. And obviously a lot of the technologies involved are quite novel, and how users are interacting with them is also changing all the time. So I think it's fair to say that the evidence base on things like online abuse is still emerging. We do quite a lot of work in the department to improve the evidence base. Ofcom already has a series of work that it does every year to look at what's going on online. I think there are some things that are relatively clear at this point, so that the scale of online abuse is huge, and that it particularly affects certain groups of people, so that we know, for example, women are more likely to suffer online abuse than men. I know there have been previous reports by the previous committee about the experience of disabled users online. So we do have, I think, quite a lot of evidence about online abuse. I don't think it's comprehensive yet, and part of that will rely on the provisions in the bill in terms of transparency and information gathering, because it's really important there's an independent regulator who has the power to access the information to really understand what's going on.
Well, I would endorse those comments. I mean, it is clearly a widespread problem. These platforms are ubiquitous. Huge numbers of people access them, including children, some of whom are under 13, which is typically the age at which social media platforms say it's safe for children to use them. So we're under no illusions about the scale of this problem. It's huge.
Okay, thank you. And just one more, really. How will the impact of the new regulations on the amount of abusive content online and the harm this causes to users be measured?
That's a good question. I mean, Ofcom will obviously be producing regular reports on their activity to work out or to assess the impact their work is having and trends within the industry. I mean, Ofcom will also have, it's worth saying under this bill, very extensive information gathering powers. So Ofcom will be able to ask companies to reveal their internal data and documents. And I imagine there'll be quite a lot of interesting statistics, data and information that Ofcom will be able to access through that process, which is currently hidden or only comes out if there's a whistleblower, like the Francis Hagen case just recently. So that will be very... And there are also powers in this bill that let Ofcom not just compel that disclosure, but severely punish any company who doesn't comply with disclosure requests, including the fines of up to 10% of global revenue. But there are also, in addition to that, for this particular question about disclosure, there is personal liability for named executives, meaning if a company doesn't produce the information, there will be the relevant named executive, would be criminally liable, as we have in financial services regulation, for that failure to disclose.
Just one last one on that. As far as named executives are concerned, and putting the blame on a person, do you think that it's possible for that to be avoided in any way?
We intend to. The clauses are drafted in a way that is designed to be precise. Either there's got to be a person named, or it's like a relevant senior director. Obviously, this is drawing on precedent that already exists in financial service regulation, where, particularly since the credit crunch 10 or so, just over 10 years ago, the concept of personal liability in financial services has existed. And interestingly, in the financial service landscape, it seems to have had a very good persuasive effect on senior executives whose behaviour seems to have improved quite a bit compared to what it was 15 years ago. So we hope it's one of those powers that never actually has to be used, because the very presence of it will compel good behaviour. But it has been drafted carefully in a way to make it sort of as waterproof as any piece of legislation can be. Not sure if you want to... No.
I was just going to... Are you finished there, Christine? Sorry. I was just going to add in there, though, on the financial services breach. Obviously, the maximum penalty is 7 years in prison, which, as you say, evidence would show it's having the desired preventative effect. Whereas the Online Safety Bill proposes, my understanding, is 2 years, and the criminal sanction is very much tied to the transparency duty rather than the wider duty of sort of preventing harm. Just wondering if you've given any consideration as to whether it needs to be perhaps broadened in scope, or perhaps increased in potential penalty.
So do you want to talk about the how the current drafting does scope, and I'll talk about other scope questions and length of sentence.
Yes, so the current scope is focused on information requests from Ofcom, which is slightly distinct to the transparency powers. So if there's that failure to provide that information, then that's when the offence will kick in. The reason why it's focused on that is because that's a really critical part of the regime, and a really critical part of the problem we see at the moment is there just isn't that information that people can have confidence in, and so it's sort of fundamental to the regime, and that's why the offences are focused there. There is one point on the sentences. I think the current proposals are based on Ofcom's existing powers in relation to telecoms, where it's the same level of sentencing, so that was our benchmark.
And in relation to scope, so you might ask the question, well, should the criminal liability extend to other duties under the bill? And clearly there's a balance, as always, a balance to strike. We don't want to deter companies from operating in the UK or have an unduly chilling effect on the market. So the feeling that I think policymakers had in developing these proposals was that focusing particularly on this information disclosure was where that is completely in their control. There's no excuse if Ofcom asks for information and it's not provided. There's just no excuse for that at all. It's kind of open and shut. So I think that kind of clarity and a desire not to have a sort of chilling effect on the UK as a place to do business was why the balance was struck in that way, I think.
Martin, did you want to come in there?
Yep. Thanks. We've heard some quite powerful testimony from witnesses on the impact of online abuse on the effect of those that receive it. So what provisions are there in the regulatory framework that the bill creates to ensure victims of online abuse are consulted and represented when it comes to tackling the issue?
Well, in framing the legislation, we've engaged, and we are continuing to engage very extensively. In fact, I think the Secretary of State is meeting with the Children's Commissioner today, possibly as we speak. We're talking to different groups who represent victims or people who suffered abuse the whole time. We've done a huge engagement exercise. Furthermore, as Ofcom, so the legislation sets out a framework, but the implementation details, precisely how these duties bite on social media firms, will be set out by Ofcom in a series of codes of practice that will be developed and published after passage of the bill. And the intention is they will go through a very extensive consulting process in drawing up those codes of practice. I mean, it might take 6 months or even 12 months because they're going to do an extensive consultation. So those consultation processes will provide a ready opportunity for people who are affected by this to have their voice heard and have their views made clear and taken on board. And I would have thought Ofcom, this is more a matter for Ofcom, but I would have thought they will be in listening mode on an ongoing basis, particularly as this is a very new area of regulation. And I'm sure as time goes by, Ofcom will want to make a number of changes as they just sort of learn about how this works in practice. And indeed, as new harms emerge that we haven't thought of at the moment, it's very likely that in like 3 years' time, there'll be problems arising that we haven't thought of today. And Ofcom will have to respond to that. And listening to victims and listening to people who are affected will be a critical part of that.
And just one thing I would add is one of the things we announced when we published the draft bill is that we also intend to include specific duties on Ofcom to establish user advocacy mechanisms. That was one of the things that's not included in the bill as published, but we have committed to include it.
That's very helpful. You've answered what I was going to ask you next as well in that. So if I just have one final point, and that's probably ties in with that, is how would you monitor the impact on children and young people specifically?
So I think that would, obviously Ofcom will have a role in terms of evaluating the impact of its interventions. The transparency reports I think are a really important part of this. So many companies already publish transparency reports, but there's no kind of independent judgment of whether or not they're an accurate representation, and it's difficult for users to compare across the board. So I think kind of once the regime is up and running, those transparency reports are kind of overseen by Ofcom, then I think there'll be a much better understanding about the impact on children and how the regime is delivering for them.
Thanks, Martin. Nick, did you want to come in there?
Thank you, Chair. I just want to actually go over a few of the answers that you've given. Well, answers. The draft bill at the moment, obviously you're going through all this different scrutiny. Has it actually is it becoming too big now, do you think, or not? Because it sounds to me as though it could be, and I'm concerned that if it becomes too large, it might actually miss the point.
Yeah, I mean, you're raising a reasonable question, Nick, but I think our intention, this is we've kind of got one shot to get this bill right, and as you say, it has gone through very extensive pre-leg scrutiny. So any changes that get made to this will have been like very carefully considered over a period of almost a year. And in fact, the path leading to the publication of this bill, I think it was 2 or 3 years in gestation. So a huge amount of thought, an unusually large amount of thought, has gone into this bill compared to others that we may encounter in Parliament. And I think because this topic is so important, and obviously this committee has heard from victims and people affected, I think it is important that we don't leave loopholes in here. Some of these social media firms are, very well resourced in terms of financially well resourced, got lots of money, and can be legally quite challenging if the legislative basis of what we're trying to do isn't sound. And so I think for those 3 reasons, it's important we make sure this does everything we need it to do. Obviously, it's not going to. There will be things that don't get addressed through this bill, but will get addressed through other bills and other programmes. But we do want to take this opportunity to make sure this is closing loopholes and doing everything it needs to protect our fellow citizens, particularly children.
Thank you for that. You talk about the terms and conditions. That's the terms and conditions for the platforms that I, as a user, would actually have to abide by. I don't know about you, Minister, but lots of terms and conditions on these websites, you just sometimes can just tick the box without reading all those terms and conditions, because a lot of them tend to be pages and pages and pages. is there anything going to be in there to make sure that the end user can understand the terms and conditions and as succinctly as possible?
Yeah, well, I'll just turn to Orla in a second, but when I talked about enforcing terms and conditions, obviously, even if some users don't understand the terms and conditions or haven't read them, the platforms certainly do understand them. And one of the problems we've got is somebody puts a piece of content online on Twitter or Facebook or whatever it may be, which is, let's say for the sake of argument, it's racist, and it violates their terms and conditions. And for almost every platform, racist content would violate their terms and conditions. But the social media platform doesn't always take it down. They ignore their own terms and conditions. And that's what we're talking about, really policing. So even if the user, just through ignorance or indifference, doesn't know or doesn't care that the racist content violates the terms and conditions, the platform should do. And they should. And what we're going to be saying for the Category 1 platforms in the legal but harmful categories, they should take action, when at the moment they don't always do so.
And just to add, there are provisions in the bill that the terms and conditions will have to be very clear and accessible to users.
It is actually in there saying that that's because people's levels of what they think is abuses can be. So I think those levels, there needs to be those lines there for people to clearly understand, and also for the legislation to be fit for purpose as well. Otherwise, you don't want any blurred. And I think there can be some grey areas with this. It's between the illegal and harmful. Who sets that? And do you understand where I'm coming from? It's difficult for ministers and civil servants to write this legislation. So for your average user to actually do that as well, it's going to be extremely difficult unless you actually set it out clearly.
Yeah, I mean, so clearly the definition of what is illegal has a very hard edge. That's contrary to statute, and there's a load of case law which essentially gives the court's interpretation of statute as applied to particular cases. In the question, and that is pretty clear. In relation to the legal but harmful to adults, I mean, there are a lot of shades of grey, as you say, and it will be up to Ofcom to make sure the terms and conditions are clearer than they are now, so they are as obvious as they possibly can be. But in terms of then applying those terms and conditions to real-world cases, obviously it'll be in the first instance up to the social media company to interpret their own terms and conditions and apply them. But if they're doing that in a way that is systematically or systemically kind of flawed, then Ofcom obviously can pull them up on that, and there'll be a sort of evolving body of regulatory case law, for want of a better term, that will provide clarity. But in it, there are certainly areas of interpretation. But the alternative is to do nothing, right? And I think clearly taking the action we're taking is better than doing nothing, even if there may be some areas of interpretation that need to be clarified over time, either by the social media companies or, if they don't do it properly, by Ofcom. Do you want to add to that?
I mean, I was just going to follow up one thing, that the point you raise about terms and conditions, because obviously we have previously had a report on the impact on disabled people of online harms, and we have a lot of petitioners who are very focused on that as an issue. So just to be clear, that the government is going to ensure that the legislation requires that those terms and conditions are easy read versions and accessible to everybody, including disabled people?
So how the legislation works is it sets that high level requirement that the terms and conditions are clear and accessible, and also things like the user redress provisions. How the framework functions is that then there's a duty on Ofcom to produce codes of practice which will set out in more detail exactly the standards that we expect from platforms. So I think things like easy read versions, how to make it accessible to different groups of users, that would be something for Ofcom's codes.
Okay, thank you.
The categories, when do you become a Category 1 platform, and who will be watching? Because you said yourself, after 3 years things can completely change, and TikTok might be number one now. So who's watching platforms come up through the ranks, as it were?
Yeah, so determinations of who qualifies as a Category 1 company is something that will be done by Ofcom on an ongoing basis, right? So it won't be like done once at the beginning and it'll be like that forever. it's an ongoing risk assessment undertaken by Ofcom. So periodically, they will review that to make sure it's up to date. And we've seen, I mean, you've mentioned TikTok, that's a good example. When the work started preparing for this bill, TikTok barely even existed. Now I think there's little doubt it would qualify as a Category 1 company. So it definitely needs to be agile and needs to be kept updated.
Thank you for that. When abuse crosses the criminal threshold, how are you going to hold these companies to account? Obviously, you'll want them to remove this content immediately. Yeah. Is there a time span on that? And will you be setting standards from that sort of key point indicators for companies to comply to?
Yeah, that's the sort of thing that Ofcom will set out in the codes of practice, but we would expect it to be, for illegal content and content harmful for children, extremely quick. You know, no messing around, no delaying. And you know, moreover, if law enforcement at the police want to investigate the criminal offence, then we would expect the platforms to fully cooperate with that investigation.
There's been some concern that the line is too weak, and the platforms to ensure their terms of service deal with legal but harmful content is too weak. Can you clarify whether Ofcom will have the power to intervene if a platform chooses to set terms of the service which deal with legal abuse in a way that it feels it leaves users at higher risk of harm from this content?
Well, the way the legislation is currently drafted is there is not a power for Ofcom to essentially rewrite the terms and conditions to say, we think you're being too permissive, be tougher, you know, ban more content. What I think it does let Ofcom do is, if the terms and conditions are unclear, it can require clarity. If the risk assessment is inadequate, so it doesn't properly assess the risks that exist, it can make them do that again, or it can even take enforcement action. But what it can't do, what it doesn't allow Ofcom to do, is actually set kind of new standards, which Ofcom can't crash in and say, we think X, Y, Z content shouldn't be allowed if it's legal but harmful. Essentially because, I mean, it's open to Parliament to make things illegal. And if Parliament hasn't made something illegal, it would seem excessive if we effectively gave Ofcom the power to kind of magically make something illegal online. That's the kind of sort of very, you're describing like what is right on the edge of where we've drawn the line.
That's where any problems will happen, though. It's on the edge where any issues will be, isn't it?
Sorry?
It's on the edge of this legislation. It's on those those places there where it's illegal, not illegal. Where it's
I think if it tips into illegal, it's kind of very clear. But I think even though Ofcom doesn't have the power to essentially impose new terms and conditions, it does have the power to make sure the terms and conditions are clear, there's a proper risk assessment, and that the companies properly police them. And actually, at the moment, most of the terms and conditions, in fact, probably all of the terms and conditions of these major companies do prohibit the things that, while legal, you and I and probably everyone in Parliament would find offensive and inappropriate. Making them enforce those existing terms and conditions is Ofcom will have the power to do, and that's a huge step forward compared to where we are today, I think.
Okay, I'm finished. Thank you.
Yeah, thank you. You said at the beginning that you're looking at the possibility of categorising according to reach and you're looking to make it into an or risk.
We're considering it. I don't want to put any more strongly. We're thinking about it.
So I just wanted to. So presumably Ofcom would be taking that assessment of risk level, and so would the government be prescribing how that risk should be assessed? How would that work in practice?
So there's a process set out in the bill where first there will be the criteria for what constitutes the high risk or high reach, and then the setting of thresholds, which will be done through secondary legislation with advice taken from Ofcom. So once that process has gone through and there are those criteria and the thresholds, then it will be Ofcom for Ofcom to decide which platforms meet those thresholds, using things like its information gathering powers to make sure it understands. And as the Minister said, it will have that sort of risk assessment and horizon scanning function to make sure that it's looking at platforms who might be coming up the track and might meet those thresholds in the future.
Okay, thank you. And just to clarify, because I understand at present, search is exempt from Category 1 designation, However, we have seen examples of harmful search. So, for example, Amazon Alexa was giving people Islamophobic search returns. Google I've seen it myself, providing anti-Semitic suggestions to people. So, while search returns might not necessarily be provided by search platforms themselves, there do appear to be algorithms within it that then can be harmful. So just wondering why Google, Bing and others are not being included within this assessment of risk and also reach, and being included within Category 1 assessment.
So search engines do have their own set of duties in the bill, which recognise that they are quite fundamentally different to user services. As you say, they don't host content directly, they sort of index it and make it available to users. So they will have duties to tackle illegal content and to protect children. So they will need to make the judgment about things like, with their autocomplete on things like anti-Semitic content, might that lead users towards illegal content? And if so, they need to take steps to mitigate and manage that risk. It's correct that they can't fall into the Category 1 category because obviously in terms of their role of providing access to information, if you put duties on search companies in relation to legal content, the tools they have available to them are quite blunt, and so that could lead to quite a significant restriction on people's freedom to access information online that is legal to access. So I think it's that balance that the Minister described earlier.
Okay. So they're not going to have a duty really not to direct people specifically to harmful content, is what I understand.
Well, they will in relation to illegal content and content that's harmful to children.
But
they won't have a duty to stop adults accessing legal content online.
Okay. I mean, I guess I'm more wondering whether there will be a way within the legislation to actually provide some kind of penalty for actually directing people to harmful content. It's this algorithm issue that we've seen with Facebook, that we've seen with other platforms, as you set out, Minister, that they make money out of, it's not necessarily deliberately wanting to promote harm, but the harm is what generates income for them. And I think search engines have fallen foul of that too. So I'm just wondering whether the legislation will address that.
I mean, they will have to do the risk assessment of their functionality. I mean, they do obviously use algorithms to rank their content. It's quite different to some of the user-to-user algorithms because they don't have the same incentives to drive engagement on particular posts. They obviously are looking to provide the most relevant post that users are looking for. So I think there is a different context there in terms of the use of algorithms, but they will have to do the risk assessment as part of their duties on illegal content and content harmful to children.
And what will be the penalty for not mitigating against those risks?
So they are subject to the same enforcement sanctions in the bill, so the fines of up to 10% of global turnover, the information offences, and in the most extreme examples there are business disruption measures as well.
Thank you. Christina, do you want to come in again?
Yeah. Thank you, Chair. The bill allows you to set out priority categories of harmful content in secondary legislation. And the government has stated that these will likely include forms of online abuse, such as racist abuse. If you're willing to commit to that now, why not include these forms of abuse as priorities in the bill itself?
Well, that's a very good question. One of the changes that are being considered, and I, again, considered, nothing's decided, would be to include on the face of the bill a more comprehensive list of priority offences. I think we've already said publicly that child sexual exploitation and terrorism would be examples of such priority offences. But there might, for the sake of clarity, early clarity, be a case for including more than just those on the face of the bill. So that is under very active consideration.
Okay. So are you satisfied that the bill does enough more generally to reflect the disproportionate abuse faced online by people from specific communities or with certain characteristics?
Well, thank you for that question. I think I just draw the committee's attention in particular to clause 46 of the draft bill, clause 46, subsections 3 and 4, which defines the concept of content that's harmful to adults. And subsection 3 says it's where the content, where there's reasonable grounds to believe the nature of the content is such there's a material risk of the content having, directly or indirectly, a significant adverse physical or psychological impact on an adult of ordinary sensibilities. But then the next subsection, subsection 4, goes on to say that if there's content which might have a particularly bad impact on people with certain characteristics, which might, for example, be race, gender, ethnicity, disability, etc., then that has to be taken into account in the definition of ordinary sensibility. So it's a really good point, and I think it's encapsulated via, as I say, clause 46, subsections 3 and 4.
Can I just ask
Order, suspension.
stopped in my stride?
The proceeding is currently suspended. The proceeding is currently suspended. The proceeding is currently suspended. The proceeding is currently suspended.
Of
The definition of particularly bad, which you quoted from subsection 4.
So it was material risk of the content having or indirectly having a significant adverse physical or psychological impact on an adult of ordinary sensibilities. And in assessing that question about ordinary sensibilities, people with certain characteristics have to be taken into account. So that's the precise wording. It's on page 41 of the bill. Draft bill.
Look at that.
Oh, thank you. So are you finished?
Yeah, it looks so.
So I do have some more questions that I would like to put to you, Minister. But if you think we have a group of votes, it might be difficult to reconvene after the votes. I mean, just very, very quickly, because I appreciate we have to go in a few minutes. But we wanted to get your view, because this is what many of the petitions have asked about, is anonymity online, and to what extent the government is considering anonymity to be an enabler of online abuse and a factor to tackle as part of this legislation.
Well, I think it certainly is an enabler of online of abuse, although it also provides protection for some people. For example, whistleblowers or people who are suffering from domestic abuse or worried about what their employer might think if they say a particular thing. So anonymity is both a threat and a protection. There are various proposals that we've heard suggested by various stakeholders. One is to give users choice about whether they see content posted by anonymous, unverified accounts. So you could, for example, give people the choice about whether to be identified or whether to be anonymous, and you could also then separately give people a choice about whether they see content posted by anonymous accounts. And we've also heard evidence and received submissions about the concept of traceability. So even if someone's profile's anonymous, like person X, looking at the public face of Facebook, you don't know who they are. Should the platform know who they are? So if the police come with a warrant saying we want to find out who's behind that account, should they have to have the information available? So those are very powerful submissions we've heard, and we're thinking about those very carefully.
Okay, I mean, obviously, broadly speaking, what the petitioners would like to know is that there is going to be accountability for abuse that is perpetrated online, and particularly Bobby Norris, who started the petition in relation to homophobia online. And you've said that where it's illegal, obviously the police are able to trace that person, but where it's just anonymous, I think that is where many of our petitioners find it very difficult to be confident that that can be addressed. Yeah. So is the government proposing to be able to challenge what the petitioners are looking?
Well, I think he's raising a really good point, and I think what we're considering I can't make any sort of firm commitment. What I can say we're considering is the concept of traceability. So if something is illegal, if it crosses the criminal threshold, then it would seem there is a case to say that the police should be able to then find the person who is behind the anonymous account if the material crosses the criminal threshold.
Yeah, but I mean, it's where it's harmful but not illegal. But that abuse is perpetrated anonymously that I think many of the petitioners are particularly concerned about, and how that's going to be addressed.
But if it's legal, then it's hard to see what basis the police would have for identifying the person behind it. Go on.
Yes, and it might also be worth just kind of going back to the buckets in the bill in terms of the platforms will have to tackle, the big platforms will have to tackle legal but harmful abuse to adults, whether or not it's anonymous. And so I think it will have a big impact on that.
Thank you. So my understanding is we have 2 votes. So I think we will need to call an end to this session. But thank you very, very much for giving us evidence today. Order.
The proceeding has ended. The proceeding has ended.